Okay, we're going to get started. If I could have everybody's attention, thank you so much for coming to our second program of the Rappaport Center this fall. We've got an exciting year planned. First and foremost, thanks to our terrific executive director, Lissy Medvedow, who you see organizing everything. She's too busy to talk, but she basically makes everything work, and we really appreciate her. This panel is entitled Peremptory Challenges, Nationwide Efforts to Combat Racial Bias. I'm not going to get too deep into the weeds on what a peremptory challenge is or how they work. I'll leave it to our terrific panelists to discuss this. I will only say that the United States Supreme Court's jurisprudence in this area under the Equal Protection Clause is rather cramped and stingy. So it allows prosecutors in criminal cases to get away with racial bias in a hidden way, so long as they can come up with a plausible explanation for it. And I'm sure our speakers are going to talk about that a lot. And we're also going to talk about efforts at the state level nationwide to have a more robust control over peremptory challenges to eliminate racial bias, including some states that have or are thinking of eliminating peremptory challenges altogether, and some states that have revised their rules of criminal procedure to cut back on the use of peremptory challenges. So that's the discussion we're going to have today, and I'm really, really excited on behalf of the Rappaport Center, where I serve on the advisory board, to introduce our distinguished visitor, Jeffery Robinson, who's going to moderate today's program, and Jeffery will also introduce our panelists. Jeffery is our distinguished visitor. He'll be with us, and he's doing a great job already. He ran a program last week that many of you might have attended. He's the CEO of the Who We Are project, and a documentary based on his project was screened last week. Jeffrey's a longtime criminal defense lawyer. He was a public defender. He was in private practice. He was legal counsel to the ACLU. He's been given awards and recognitions, including being elected to the American Trial Lawyers Association. He's also been given a prestigious prize by the state of Washington for his efforts to combat racial bias, including his efforts to revise the Washington Rules of Criminal Procedure on peremptory challenges. So he's done a lot of great work in this area, and we're so delighted to have him as our visiting scholar this semester. And my only regret is that I teach on main campus in just a few minutes, so I can't stay for the whole program, but I'm sure it's going to be absolutely terrific. So thank you, Jeffrey.
Thank you very much. I am thrilled to be here, and thank you all for coming. We have an incredible panel, and I know their bios have been passed out, so I want to get right into this so that we can have as much time with our panelists as possible. And this is where we're going to start. When you're talking about jury selection in courtrooms in the United States, and I'm going to give this as a really quick summary. There are two kinds of ways that you can get rid of jurors in a criminal case or a civil case. The first is a cause challenge. That's something like the juror is related to somebody in the case, or a juror has a financial interest in the case, or a juror in a criminal case were to say, I trust police officers, they never lie, I will believe them no matter what they say in every circumstance. That's a challenge for cause, no mystery there. Peremptory challenges is what we're here to talk about. That's a challenge where you can excuse a juror for any reason whatsoever. It doesn't matter. And this has a long history going back to the 13th century in England. And in 1790, if you were charged with a capital crime here in the United States, you got 35 peremptories if you were charged with treason and 20 with any other capital crime. So peremptory challenges have been around forever. And the idea is that if both sides of the case get to shape the jury, then both sides will have more comfort with the result, and the community will have more comfort with the result as well. And so while peremptory challenges have been widely recognized, they haven't reached or been given constitutional status. So Batson versus Kentucky, 1986, a seminal case, and here's what's going on with this case that we need to know about. First of all, James Batson was charged with second-degree burglary and receipt of stolen goods.
The prosecutor struck all 4 black jurors that were on the panel, which resulted in an all-white jury. And this is what the Supreme Court said. Defense counsel moved to discharge the jury on the ground that removal of the black veneermen, meaning jury people, violated petitioner's rights. Well, that's not quite accurate. And I'm going to have you listen to, from this podcast, Object Anyway, James Batson himself telling you how the error in his case was preserved.
What's important for our story is to know that James Batson is sitting there in the room as all of this is happening.
And I'm like, that's completely, they struck all the blacks off the jury pool. It ain't right. And I told my lawyer, I said, you object to that,
Lawyer says, why would I object? James said, because it's not fair.
He said, no, that's a long-standing rule.
He's allowed to do that.
And he can strike whoever he want.
Was he lawyer white or was he black?
He was white.
And was the judge white or black?
He was white.
And aside from those 4 people that had just been struck off the jury,
everybody in the courtroom was white.
So again,
told my lawyer to object.
And again, the lawyer says,
he said, no, I told you can't object to this. I said, what do you mean you can't? You work for me, you do what I say, you object anyway. I don't care if it's a long-standing rule. Object. And he did. And it all came behind that one objection.
Batson versus Kentucky never would have happened because the lawyer told James Batson, this is the way we do things. This is a long-standing rule. The one thing I would ask every single one of you as law students to remember, long-standing rules mean nothing other than they've been long-standing. It doesn't mean that they're right. So the Supreme Court said, we have to now re-examine that portion of Swain versus Alabama, a prior case. We have to re-examine that portion of the case that talks about what a defendant has to prove in order to succeed on this kind of challenge. Here's a portion of Swain that was not changed. They had wonderful, beautiful language. The harm from discriminatory jury selection extends beyond that inflicted on the defendant and the excluded juror to touch the entire community. The only problem was, here's the portion at Swain that they had to re-examine. Because what they did in Swain was say all this beautiful language, and then the court said, well, we're going to presume that the prosecutor had a good reason. So we affirm the conviction and you go off to prison. And what Swain said is, well, we're not going to do that in the future, but here's the new test to figure out if you are being discriminated against. If in case after case, whatever the circumstances, the crime, the defendant, or the victim, the state uses peremptories to remove Negroes who cannot be removed with a challenge for cause, with the result that Negroes never sit on a jury. So if I'm black, I gotta wait for 8 or 10 other black people to go to trial, have all the jurors in their case excluded, and then I can say, I think my rights are being excluded. And the Supreme Court was like, that's probably not the most workable or just rule in the world. So Batson's gonna fix it. Here's the Batson fix. Just be a member of a cognizable racial group and the prosecutor removes that group from the jury. And then based on all the relevant facts and circumstances, you must prove by a prima facie case, meaning just enough evidence to believe it, you must prove that the prosecutor did it on purpose. And if you do that, the burden shifts to the state. So you're thinking, wow, this is a pretty good rule, right? So what does the state have to do? Yeah, you can't say, I didn't have a discriminatory purpose, Your Honor. You gotta say more than that. You can't say, well, Your Honor, I'm a really good person. You gotta say more than that. But if you say, Your Honor, I didn't like the way he was dressed, that's fine. Just give a quote unquote race neutral reason. And the judge uses all the relevant circumstances to decide that. So I'm gonna throw it first to Lila Silverstein, public defender from the state of Washington. And you may think, why is she here as a public defender? Well, I don't know, maybe because she was counsel in the case that invalidated the death penalty in the state of Washington on racial bias, and maybe because she was one of the lawyers who drafted GR 37, the rule in the state of Washington has said, Batson, forget about it. We're gonna do this a different way. So Lila, Batson is out there. What's the experience in the state of Washington? How's it going?
Well, Jeff, is this on, by the way? Can you guys hear me okay? No, we can't hear you. Okay, I'll wait for them to turn it on, or do I need to turn it on? And probably need to hold it right up. But is it on? All right, now can you hear me?
Yes.
All right. Well, let me just say, to answer your question, Jeff, that Batson did not work to prevent race discrimination in Washington or anywhere else in the country. In fact, in a 2010 report, the Equal Justice Initiative concluded that there is perhaps no arena of public life or governmental administration where racial discrimination is more widespread, apparent, and seemingly tolerated than in the selection of juries. Now, that's a remarkable statement, right? Because racial discrimination permeates every aspect of society. And the Equal Justice Initiative is saying, yeah, but here's where it works, in jury selection. So why is that? Well, basically, as Jeff indicated, it was far too easy for lawyers to come up with an ostensibly race-neutral reason for excluding jurors via peremptory challenge, and it was way too hard for the other side to prove purposeful discrimination. And so these are problems that the Washington Supreme Court recognized in a case called State versus St. Cali. And not only did they recognize that it was too hard to prove purposeful discrimination, but they said, look, judges don't want to accuse members of the bar of being racist, which is essentially what you're doing if you're finding that the lawyer engaged in purposeful discrimination.
Are you saying that a judge would be reluctant to tell a prosecutor that appears in front of him or her every day of the week, I think you're a racist?
Believe it or not, yeah, and not only that, but the other side is afraid to object for the same reason. So this was a problem. And the Washington Supreme Court said, and you know what else? A lot of discrimination is unconscious or due to implicit biases. And the Batson standard doesn't seem to reach that because it requires proof of purposeful discrimination. So what we saw countless times over the years, both in Washington and everywhere else, is that the exclusion of jurors of color was justified based on two primary types of reasons. First of all, their exclusion was justified based on their negative experiences with the police or justice system. Prosecutors are going to call police officers as witnesses in their cases, and they don't want jurors who distrust the police. But the problem is that because racial bias permeates every aspect of the justice system, including stops, arrests, searches, and so forth, if you're going to exclude someone on that basis, you're just re-victimizing them, you're perpetuating systemic discrimination, and you're losing important voices on juries. Now, the other major justification that has historically been given to exclude prospective jurors of color is alleged problems with their demeanor, and Jeff alluded to this, or their intelligence. You know, our perceptions of other people's demeanor are influenced by implicit bias. And in fact, this is a problem that Justice Marshall warned would occur in his concurring opinion in Batson itself. He said, you know, guys, it's great that we're overruling Swain versus Alabama, which Jeff just talked about, but he said, this isn't going to work either. And he said, among other reasons, a prosecutor's own conscious or unconscious racism might lead him easily to the conclusion that a Black prospective juror is distant or sullen, a characterization that would not have come to mind if a white juror had acted identically. And you know what? A few decades later, the Equal Justice Initiative found that this, in fact, came to pass. They studied numerous trials in 8 southern states and found that prosecutors frequently justify the exclusion of jurors of color based on unverifiable assertions about their demeanor, things like not paying attention or that sort of thing. And they also found that a shockingly common reason given for excluding jurors of color is an alleged lack of intelligence. Now, this problem was not unique to southern states. This problem happened in Washington also. So it doesn't matter if you're a red state, a blue state, a southern state, a northern state. We saw the same things happening in ostensibly progressive blue Northwest Washington state. In fact, in the St. Cali case itself, the prosecutors falsely described the only African-American prospective juror as checked out and falsely described the only Latina prospective juror as not very intelligent. No offense. That's what they said. And of course, the statement was offensive, notwithstanding the disclaimer. And it was factually false. So we have these problems, and what did we do about it? Well, we created in Washington a new court rule to replace the Batson standard. And Jeff has already put it up there for you. This is the core of the rule. In Washington, you don't have to prove purposeful discrimination anymore. Instead, the use of a peremptory challenge is invalid if an objective observer could view race as a factor in the use of the challenge. So this addresses not just purposeful discrimination, but also implicit bias. And the definition of an objective observer is somebody who is aware of the history of purposeful discrimination and systemic and implicit biases. So you can't get away with a peremptory by pretending that this objective observer doesn't understand what really goes on in the world. And then importantly, Washington's rule renders presumptively invalid the types of justifications that have historically been used to discriminate in the exercise of peremptory challenges. It is presumptively invalid to exclude a juror based on their negative experiences with the police or justice system. And when it comes to allegations about a juror's demeanor or intelligence, you can't exclude a juror for that reason if you didn't raise the issue when you saw it. You can't invoke this type of justification as a post hoc justification for a peremptory challenge. So if you see a juror supposedly not paying attention or giving unintelligent answers to questions during voir dire, the questioning of jurors, then you have to raise the issue with the court and opposing counsel when you see it, so that the concern can be either verified or dispelled. Otherwise, you can't use that as an excuse after the fact. So this is Washington's rule. It's been in effect for 4 years now.
And what's the impact?
Well, we believe anecdotally that this rule has worked really well. That people are far more aware of their implicit biases. They're more careful in the exercise of peremptory challenges. That there is much less race discrimination in the use of peremptory challenges, and that juries are more diverse. And we are really grateful to our Supreme Court for having the courage to adopt this bold solution, necessary, but bold solution to this pervasive problem.
Well, I'd like to go to Judge Gates, who is appearing with us on Zoom, and I don't know if you'll be able to see us, but Judge Gates, are you there?
I am.
So we are hearing you loud and clear, and Judge Gates is from Arizona. And Arizona took a different tack in trying to address this problem. Judge Gates, could you describe kind of what the process was in Arizona and what y'all ended up coming up with?
Absolutely. So first, to understand our system in Arizona, preemptory challenges are not statutorily based. They are based in rule that has been adopted by the Arizona Supreme Court. So our Supreme Court created a task force that I had the honor of being the chairperson of. And we were asked to look at every aspect of jury selection and identify obstacles that prevent our juries from clearly reflecting the diversity of our community. So we looked at compensation of our jurors, the source list of how we summon jurors down, the summoning practice. And the Supreme Court also asked us to give them an opinion on whether we perceived preemptory challenges should be eliminated or whether the preemptory challenge system should be changed. While our group was researching this, the Arizona Supreme Court was reviewing 2 rule petitions. The first rule petition was modeled after Washington's Rule 37. The second rule petition was proposed by 2 Court of Appeals judges here in Arizona and proposed the complete elimination of preemptory challenges. The Supreme Court decided to completely eliminate preemptory challenges in all Arizona jury trials, from eviction cases to death penalty cases. No preemptory challenges. The Supreme Court then referred back to my task force the request to look at all the rules and determine whether changes should be made in the rules that control jury selection to ensure the protections of due process and to ensure that we are impaneling individuals who can be fair and impartial jurors in each trial. So we then added to our task force and tried to get an incredibly broad cross-section of practitioners and judges. Judges from municipal courts, justice courts, trial courts. I'm from Maricopa County, so we have the 4th largest trial court in the country, to some of our rural courts where their counties require some jurors to drive 6 hours just to get to the courthouse. From that group, we then recommended to the Supreme Court a series of additional changes to our rules. In Arizona, we pride ourselves in being an evidence-based practice court, which means we try and anchor all of our changes in research and data. We worked with a number of PhDs and reviewed the data on practices to ensure a fair and impartial jury. And what we discovered was that the research was pretty consistent with our own individual experiences. And that is that jurors are willing to provide honest and candid answers to the court's questions, but they have to be asked the right questions. And it's most effective if they're asked the questions in certain ways. So I can't see any of you, so except the panelists, but this is sort of like jury selection. You had an opportunity to hear a little about me. I gave you some background. And now I'm going to ask you by a show of hands, how many of you have been the victim of a sex offense? If you could just raise your hand. I'm not actually asking you to do that, but that's jury selection. We are asking people to reveal some of the most personal and private information about their lives, their attitudes that may not be socially, that may not be perceived as socially acceptable. And we're asking them to do that in the presence of the veneer. And jurors often express a reluctance to do that. So in Arizona, we added a rule that urges judges to use case-specific written questionnaires. And then we created a digital questionnaire that we made available to all of our judges in Arizona. So the way that many of our trials proceed now, our jurors arrive at the courthouse, they're handed a QR code, and then they're asked to use their smartphone, or we give them iPads and laptops, and they privately answer questions that are created by the judge and the parties that are reflective of the issues relevant to that particular trial. So in the instance that I just gave you, they may be asking, have you been the victim of a sexual offense, or anyone in your family or close friends been the victim of a sexual offense? Help us understand that experience. What happened? Do you think as a result of that experience, you might favor one side or the other in this case after you hear a summary of the case, which we give them? And then the lawyers and the judge digitally review those answers. The other part of the rule is that we've always allowed attorney-conducted jury questioning of our members of the veneer. But we changed the rule to encourage judges to allow sufficient oral questioning by the lawyers. The research demonstrates that jurors are more willing to be candid and honest to the lawyer's questions than they are to leaded questions asked by the court.
Judge, I just wanted to ask you a question about that, because do you think that has something to do with the authority that you have as the trial judge, in terms of if you're asking a juror a question and the answer might reflect negatively on them, they're less willing to say that to a sitting judge in robes and up on the bench?
Absolutely, and that's corroborated by the research. And sometimes it's simply the form of the question that we ask. If we ask an open-ended question, so for example, what made you say that? If a person indicated, I may always be inclined to believe a law enforcement officer, using Jeff's example, the judge might say, what caused you to say that? Help me understand why you gave that answer. Instead of saying something like, well, I'm going to give you instructions that tell you that you have to give every witness equal credibility and believability, that you can't give a law enforcement officer greater believability or credibility simply because they're a law enforcement officer. Juror number 14, you'll follow the law. You'll follow the instructions I give you, right? A juror, and the research demonstrates, is more willing to answer that leading question of the court in a way that is perceived to be favorable to the judge. Conversely, if we're just exploring the juror's answer, getting narrative, honest answers from the juror, then we as the finders of fact, we as the judge and the parties, use those facts and apply it to the law to determine whether or not those individuals can be fair and impartial jurors in that particular case. So we also discourage, as part of our new rule set, judges from asking those leading rehabilitative questions. So we made some significant changes in the way that we are asking questions during jury selection. In Maricopa, our judges are overwhelmingly using the jury questionnaire and are very positive about their experience. Anecdotally, we are seeing a lot of jurors provide answers that we didn't see before. We always see some jurors who are wanting to get off the jury and will say anything to get off the jury. But we are seeing more candid, raw, honest answers. We also have changed the way that we talk about the information we are extracting. So instead of asking an undefined term, can you be fair and impartial? We talk about beliefs, attitudes, life experiences. We encourage honesty. We talk about no right or wrong answers. So we try and encourage jurors to give us more information. And as the last point, before I turn it back to Jeff, in one of the research papers that we cite in our petition up to the Supreme Court is Dr. Salerno out of ASU and a number of other individuals at various institutions of education that researched limited voir dire versus extensive voir dire. And when they were asked, prospective jurors were asked sort of those, can you think of anything that might impact, impair, interfere with your ability to be fair and impartial? Less than 2% of the prospective jurors articulated a basis that could serve as a motion to strike the juror for cause. Then when you change the approach using more extensive voir dire, approximately 42% of the jurors on the panel articulated a basis that could serve as a reason to remove that juror for cause, which indicates to us as judges, jurors are willing to provide honest and candid answers to the judges and the parties to be able to assess if they can be fair and impartial. But we have to ask the right questions, and we have to approach jury selection in a thoughtful and thorough way.
Judge Gates, thank you so much for that, because asking the right question in the right way, a question that says, tell me more about that. If you ask someone why do you believe that? People may see that as a challenge. You know, you're questioning, but if you say, tell me more about that, What people are willing to do is to talk to you. And the best introduction I have ever heard to a jury selection was a young Black woman in Kansas, a public defender, who stood up and said, "Ladies and gentlemen, in the United States of America, we have something called the First Amendment. It says that you get to say what you think about important issues, and it doesn't matter what the judge thinks, what that prosecutor thinks, or what I think. What I'm asking you to do for the next hour and a half is to exercise your rights under the First Amendment to say what you believe." And I have seen that on numerous occasions have a major impact on what jurors are willing to tell you. I want to go to now to Judge Lowy, because Judge, you have been grappling with this very same issue, and I think your court is perhaps taking a different tack than what Judge Gates is taking. How is your court grappling?
Well, we are grappling without doubt with the issue. I have suggested in a couple of concurrences that the best way to have some impact on racial bias in jury selection is to eliminate the first step in the Batson analysis. By eliminating the first step in the Batson analysis, what you do is you require the party that is making the peremptory challenge to provide an adequate and genuine reason for that challenge.
So Judge, for just a second, so what you're saying is, as opposed to initially demonstrating that this challenge has been made and it's a problem, when the person makes the challenge, they have the responsibility to justify that challenge.
Exactly. So that way, the judge has an opportunity to evaluate the reasons for the challenge, and it's not enough that the reason for the challenge is adequate. In other words, it provides a reason other than race, ethnicity, gender, sexual orientation, whatever it might be. It's not enough that the reason given is genuine, is adequate. It also has to be genuine, which requires the judge to make a credibility determination of the prospective juror. It seems to me, I'm not surprised that Rule 37 in Washington State has had some impact. I'm not surprised that open-ended questions when addressing issues of cause have had some impact. And open-ended provisions on cause are important for a number of reasons and would become even more important if we eliminated step one. However, the only way to make significant progress, in my view, is either to eliminate step one or eliminate peremptory challenge. I expect, but I do not know, that there won't be much of an appetite in Massachusetts to eliminate peremptory challenge. And I want to use as an example of a reason to eliminate step one, sexual orientation. We have determined in Massachusetts, as have some other states, that a peremptory challenge is not permitted based on your sexual orientation. So if an attorney challenges somebody and the opponent of the challenge indicates, well, I think that's based on sexual orientation, what does the judge do next? There's no good answer. Judge Gates referenced questions about raise your hand if you've been a victim of sexual orientation. That's just not going to happen. As she said, I was a trial judge for 19 years, and it was very infrequent when you asked out of a general question, not at the sidebar, is there any reason that you believe that you would not or could not be indifferent and impartial and be able to render a verdict without consideration of, for instance, race? And you'd have 90 jurors in the audience, and nobody would raise his or her hand. either.
It's essentially asking, are any of you racist who are gonna be unfair? And the jurors are like, not here.
Right. And that doesn't address the implicit bias part of it either. I think in the context of sexual orientation, it doesn't seem right to say to the juror, well, what's your sexual orientation? All they've done is come to jury duty. And then we don't want people sitting there at the sidebar pontificating, lawyers pontificating based on stereotypes, what the person's sexual orientation is. That seems pernicious. It seems to me the way to be fair as it relates to that issue is to eliminate stuff. I want to pick up on another issue that Attorney Silverstein mentioned, and that Attorney Robinson elaborated on as well, which is, well, basically, if you move to the next step, the second step of Batson's Good, well, give me a reason for the challenge. That you are basically saying, okay, I think you're a racist, and the attorney who has made the challenge maybe has been trying cases for 15 years against the prosecutor, and they have a practice of going out for beer and sushi after trial when the trial's over because
Gee, you
collegiality
called
is
me a
important.
racist in front of Judge Lowy? You called me a racist with this challenge? How could you do that?
And some judges, like me, tended to sit more often than not in the same county. I mostly sat in one county. I had prosecutors trying their 20th, 30th case in front of me. So it seems a lot to put that on the lawyers and on the judge. So my view is that the best way to address this is to eliminate step one. Our former great Chief Justice Ralph Gans, when I wrote my first concurrence on this issue, said that to paraphrase, well, I'm really interested in looking into this, but let's wait till we have briefs right on point.
Well, Steve, you represent people who are sitting in a courtroom saying, those are the 12 people that are going to decide whether I go home or whether I go into prison. What is your view on the importance of peremptory challenges and this issue of how they may be used in a racist fashion?
I love that you start with the perspective of the accused thinking about those 12 people who brought Mr. Batson here into this discussion, in his own words, and if you'll indulge me, I'd like to try to think through the perspective of a client as they go through this process. As I thought about it that way this morning, it helped clarify the reasons why I believe that the use of peremptory challenges are so essential to making sure that the jury that's selected is fair and impartial, and providing the accused with a voice and feeling of empowerment within the process.
There are not a whole lot of places where a person charged with a crime is going to feel empowered in that experience.
And you certainly don't feel empowered when they wake you up at 5:30 in the morning. It's earlier than you're used to being woken up. Might still be dark outside. And they woke you up that early because it's your trial date. And you leave early. They offered some semblance of a breakfast to you. You weren't going to get breakfast at normal time, but you're really too nervous to eat. They take you into the intake area. The last time you were there was when you were arrested and brought in. You came back from your, went there, came back from your arraignment, and came in and smelled the same, that smell of plastic and milk breath, and they hand you the clothes that you were arrested in, which is a pair of mesh shorts and a t-shirt. They handcuff you at the hands and the feet. They put you in a van. The van has no window. You're sitting back, shackled that way, seated next to the other people that are going to that court and other courts within the county. You start feeling a little better when you get to the Cambridge District Court. The court officers there are very friendly with you. And in fact, when they finally offer you some more food and final information, maybe eat a little bit more. Your attorney had talked to you the night before. One of the main issues that you had talked about was clothing, because you didn't have it. You brought some clothing on a guest that you sort of got larger since you went to jail. That's what happens when you're no longer using fentanyl and you're taking care of yourself, exercising more. And so the shirt doesn't fit. And the attorney seems hairy. He's trying to find some other shirt, he's texting colleagues, and the first time you go out into the courtroom, and you're still wearing those special shirt. You still have those handcuffs on, and you notice that the judge seems to be annoyed with your attorney because the attorney's asking more about the handcuffs, and can we ask, questions of the jury pool, more questions that you didn't really think through with the attorney before. And you really didn't actually talk much about this jury selection process. You were really talking more about what the evidence is at trial, what our chances are. And a lot of this seems surprisingly new and certainly nerve-wracking. And you wonder a little bit as that judge responds to your lawyer if it's because you have a public pretender as a lawyer. You think, maybe if I had had a private lawyer, this would be going a little bit better. But if I had the money for that private lawyer, I probably would have paid the bail that was keeping me in jail in the first place. You go back into lockup, shirt comes, it actually fits. And when you walk back into that courtroom, you have a modicum of dignity in the way you present yourself, and all of a sudden, a large group of people, like the group here, walk in and fill the gallery. And your lawyer tells you as a series of questionnaires come in that we need to go through these questionnaires. We need to think through based on the answers, is it someone we want to pick? But the process is going really fast. The judge is asking questions of the pool, they're holding up cards, you're flipping through all the pages, your lawyer's making notes about who seems like a good juror, who's not a good juror, I don't really know. The judge did provide some nice instructions on bias, taking account of our biases. And the attorney talks to you about trying to go up and ask a few more questions at the sidebar area, which she explains the area by the judge, but recommends that you stay at the table.
So you mean that when this conversation is going on between the judge and the lawyers about who's gonna sit on the jury, I, as the defendant, am not a part of this conversation?
You weren't a part of this thing. You had the election and the choice to, but your lawyer told you maybe it'd be better just to sit here and stay at the table. Maybe that was the right choice and maybe not. You did feel excluded from the process. You were sitting there with a pen, and the real pen, not the flimsy one they give you at the jail. But you really don't know what to write because you're not really hearing anything. And you can't really see anything because you had your glasses taken from the incident that also resulted in 2 chipped teeth. That mean that you showed up there that day and really in no position to handle something this serious. And your lawyer says, I'll come back and talk to you about what the jurors had to say. You see people come up, you see people seated, and eventually after a while, the lawyer comes back to you and says, look, I think the jury pool looks pretty good. I got to ask a lot of questions. Juror 6, they had an issue with juror 6 because I asked about bias. What I got to ask was, the lawyer seems really hurt. What I got to ask was, do you think that there are biases that we don't necessarily take account of or don't admit to ourselves that influence the way that we think and act? And that potential juror said, absolutely not. I'm not biased. I don't have feelings like that. I do know that it's a big topic and that we have to give presentations on it at work, but not make my own secret. And as you talk to the client about it, he had the feeling that when that juror walked up, he had heard him say something. He can't quite put his finger on it, but he thought he heard him say something. And the lawyer said there was something about the way he was responding to it. It wasn't necessarily the words. And the lawyer tells you that actually you can get rid of 2 people for any reason. And you get rid of that one. You get rid of that jury member. And for maybe the first time that day, you feel empowered. You've actually made a choice. You actually feel maybe a little bit more than you did when you walked in there, but you are innocent. It certainly didn't feel like that on the van. And after you're convicted and you're sentenced to 18 months in the House of Corrections, and you serve that sentence, you don't have to think every day of those 18 months. You don't have to wonder to yourself whether that juror number 6, was the reason why you were convicted, was the person that helped to provide a viewpoint to the jury that a Latino man was more likely to have been violent in the encounter with a white man if you were accused of assaulting and battering with a dangerous weapon.
And let's be clear, the answers that juror gave at the sidebar where your client can't hear it, that does not get you a challenge for cause.
And your lawyer tells you, I challenged them for cause. I did. I said, Judge, that seems problematic to me because they're not buying, they're not willing to accept the premise that we all know to be true, that we are influenced by implicit bias. So the judge asked whether or not the juror feels that they would act in a racist way if forced with that, if confronted with that concept. Your lawyer explains to you, and the person said, absolutely not, I am not a racist. And your for-cause challenge found it.
These are the issues that come up when we think about what role does the court play in deciding who sits on the jury, and what role do the litigants play? In a criminal case, we're really talking about the person accused of a crime. And what I can say as a public defender at the state level, a public defender at the federal level, and then in private practice, is there were jurors in cases that I tried where I could not articulate fully the reason that I didn't want them to sit on the jury. Most often it had to do with reactions to police officers. And if I didn't have the ability to excuse someone who basically says, and this is universal. A juror says, how do you feel about the police? I basically trust them, they have a hard job, and I trust them. 99% of courts across America will say, that's a completely great juror. Why is that? Why is it the definition of a good juror that it's somebody who trusts the police? Does that make you a good juror in a case? But that's the assumption. That answer is an okay answer. And if I don't have a peremptory challenge, what I worry about is that there are people who are going to sit on the jury with views that I think will impact the way they hear my defense, and I'm not going to be able to get rid of them. I want to go to Judge Gates real quickly because Arizona has eliminated the peremptory challenges, but what Arizona is doing, as I heard it, is they not only have attorney questioning, but there is a questionnaire where people are writing answers, and the lawyers get to look at that before they have any discussion with the jurors. Judge Gates, can you tell us what the lawyers have been saying about how they're experiencing the new rule there?
So thank you for the question. We have surveyed our lawyers, we've surveyed our jurors, we've surveyed our judges, and the lawyers are very positive about the questionnaire. In Arizona, we have different summoning practices. So in the urban county, or the urban counties like in Maricopa, we can't administer the jury questionnaire until the jurors arrive in the courthouse, because we just have a group of people who show up, and then we create the jury list for the different trials that are going that day. So we don't know what jury is going to be going to Judge Gates until all the jurors arrive. So one of the criticisms that we hear from the lawyers is they don't have enough time to digest the answers to the questions. So what would happen is the jury would arrive, they'd get the questionnaire at about 8:30 in the morning. It takes around 15 minutes for the jurors to complete the questionnaire. We receive the answers in real time. So we're using Microsoft Forms in Maricopa County, but other courts use Google Survey or other platforms.
Right.
And then we look at the Excel spreadsheet together that compiles their answers. If you ask about 30 to 40 questions, it's relatively easy to digest. If you ask 100 questions, it's much more time consuming. So the most significant criticism that we hear is that lawyers don't have enough time to digest the answers. Candidly, I think sometimes the lawyers want an opportunity to look at the answers to juror number 7 and then go back and look at the biographical information and the other information that they have available, instead of just blindly looking at juror number 7. So I know sometimes we deprive them of additional information, but in my opinion, if the answer from juror number 7 is X, and that juror is Black, and the answer is X for juror number 27, and that juror is white, those jurors should be treated the same, and you don't need to know the biographical information of those jurors. They should be treated equally and evaluated accordingly.
And I guess part of what's going on there, Judge, is the concept that if I am a corporate officer or if I am a sanitation worker. If my opinion on a subject that's important to the case is the same, then my employment shouldn't make any difference.
Correct. And I think, there was something that was brought up earlier, and that's this concept of a juror who's not smart enough, or a juror who's not sophisticated enough. Or you hear, this juror is just not able to serve as a juror. I think we have to reflect back and indicate that the parties are entitled to a jury of their peers. Of course, jurors have to perform the essential functions of their responsibility and be able to understand the testimony and reflect upon the exhibits. But I grew up in a rural town in Iowa, and I remember talking to one of my criminal defendants in a settlement conference, which is a procedure that we have in Arizona. And I explained that most of the jurors will hear the testimony about his alleged offense, that he started a car with a screwdriver. And most of the people on the jury will have driven to the courthouse having started their car with a key. And they won't understand that sometimes people just start their car with a screwdriver. Growing up poor in a farm town in Iowa, we started our car with a screwdriver. It didn't mean it was stolen. It just mean you lost the key and you couldn't afford to pay for a new key.
And you still needed the truck to get out to do what you were doing, so you had to start it.
Right, you had to start it somehow. So I do think that it's important for us as judicial officers and for parties to reflect upon who the jury is entitled to be. And we shouldn't just remove somebody because, in our opinion, they're not smart enough. I think we have to be very critical about what that means.
And I will just say, Judge, that it's interesting because Lila will correct me if I'm wrong, but the juror in St. Helier, who was described by the prosecutors as not quite smart enough, was a single mother who had raised 3 kids, put herself through school, and was employed, I believe, as a dental assistant. So what about that demonstrates that this woman is not smart enough or capable enough to sit on a jury? And yet the reason that the prosecutors gave was she's not smart enough. And I would suggest is that they could not articulate anything else about their real reason, which was she's Black, and I really don't think she's going to trust the cops in this case. And the cops in this case have a big deal to do with the evidence. Lila, you've heard Judge Gates talk about getting rid of peremptories in Arizona and their use of questionnaires, which I think is very interesting. Also, one thing I just want to emphasize, when Judge Gates talked about instructions to trial judges not to use leading questions to rehabilitate a juror, I can't tell you how many times I have been questioning a juror when they essentially say, yeah, Mr. Robinson, I hate your client and everything about you and your case. And then the judge comes in and says, yeah, but you can be fair, can't you? And they say, yes. And the judge looks like, okay, that problem is solved. By asking judges not to do that, and by asking open-ended questions, one of the things I want y'all to think about is we've got elimination of peremptories, a brand new rule, struggling with a rule, the perspective of a person representing people. You can take bits and pieces from all of these perspectives, and that's what I think is going on around the country. People are trying to figure out how can we select jurors in a more fair way. Lila, I want to come back to you real quickly because one of the things that Swain versus Alabama said in its beautiful language is that it's not just the criminal defendant who is damaged when a person of color is removed from the jury. It's the juror themselves. And whether y'all know it or not, I actually have a right to sit as a juror. It's because I'm a citizen under the 14th Amendment. And you can't take away my right to sit as a juror based on my race without violating the Constitution. So when we think about what kind of leeway should be given to litigants to choose who will sit on their jury, We think about the rights of a criminal defendant, and those are paramount and critically important, but they ain't the only rights that are at play.
Well, that's right. And it is an important right of the juror as well. And, partially for that reason, I know I'm biased, but I do think a rule like General Rule 37 is even slightly better than eliminating peremptory challenges or eliminating step one, even though I think doing anything is a million times better than doing nothing. Because we have a big problem and there are multiple possible ways to fix it. But I think a court rule like General Rule 37 or California statute that was modeled on GR 37 is a little bit better to protect not only a defendant's right, but a juror's right. I will admit in candor, that's not the reason that in Washington we chose a court rule instead of eliminating peremptory challenges. The reason we went that route is because trial attorneys of all stripes were opposed to eliminating peremptories. And both Jeff and Steve gave good reasons for that from their perspective, but it's not just criminal defense lawyers. Prosecutors were opposed to eliminating peremptories. Civil plaintiffs' attorneys were opposed to eliminating peremptories. Civil defense attorneys were opposed to eliminating peremptories. And in fact, one of the members of our drafting group is a civil plaintiff's attorney who said, you know what? You can pry peremptory challenges out of my cold, dead hand. So we crafted a different solution that was more palatable to these stakeholders and which addressed the primary problems with Batson. But in hindsight, I now think that GR 37 is actually even better than eliminating peremptories. And I say that because GR 37, while it only explicitly addresses peremptories, also provides an important overlay in other contexts. And our Supreme Court has imported the GR 37 standard in multiple contexts now. But for purposes of today's discussion, what I want to emphasize is that GR 37 provides an important overlay when assessing challenges for cause. And both Jeff and Judge Gates have discussed challenges for cause. That's the type of challenge where you have to show actual bias to remove the juror. Well, research shows that, not surprisingly, there is extreme racial disproportionality in the use of challenges for cause, just like there is with peremptory challenges. And if you eliminate peremptories, then that's great that you're completely eliminating race discrimination in the use of peremptories as well. But you're almost certainly going to expand the use of challenges for cause. And in fact, I have heard people in Arizona say that they have promised to expand access to challenges for cause. And so you're probably going to expand the racially disproportionate use of challenges for cause. And I am particularly concerned about a problem that Jeff just alluded to as well, which is the use of challenges for cause to exclude those jurors who don't trust the police because they have been victims of racially biased policing, right?
In fact, you could say to yourself, with all of the publicity about policing in the past 10 years, if you had a juror that says, yes, I'm aware of all of that and it doesn't bother me a bit, I think police are the greatest institution in America, you could have a problem with that person. I might say to a judge, I want a challenge for cause against this person, because with that articulated view, in light of the evidence, nobody in America can say there's no problem with policing. You have to shut your eyes to all of these problems. And if he's shutting his eyes to that, then I don't want him sitting on this jury.
Right. But the problem is, and at the beginning of this presentation, both Jeff and Judge Gates gave an example of using a challenge for cause to exclude somebody who trusted the police no matter what. I'm going to tell you that never happens. What happens is only the opposite, that people are excluded either both for cause and for peremptory challenges if they don't trust the police, even though it's just the flip, right? But lawyers allege and judges find that you have actual bias if you don't trust the police, whereas you don't have actual bias if by default you do. So that's a big problem. Now, in Washington, with General Rule 37, distrust of police or negative experiences with the justice system in general is a presumptively invalid justification, even for a peremptory challenge, which generally requires no reason at all. So it is by definition insufficient on its own to support a challenge for cause. And I think that is critical for reducing race discrimination in jury selection and supporting the rights of not just the defendants, but the jurors. And I want to show a video right now.
You know, let's keep moving because I
Okay.
just don't know if we have time. I want to ask a couple of other questions, but maybe come back to this if we can at the very end.
Or you can email me, ask for the link if you want to.
There's a
Quiz
video
pool.
of a
You wanna
young
see it?
woman who was excused with a peremptory challenge from a criminal case. She testified before the state Supreme Court about her experience of that result. And it's something that we as lawyers don't often think about. We always say, don't worry about it. If you're challenged, it's not meaning, it's no personal insult to you. It's just, the lawyer's trying to win their case. But especially in the criminal legal system as it exists today, that's a very different subject.
Jeff, could I very briefly
Please,
add
Judge
something?
Gates.
So in Arizona, we do frequently see both sides. So I understand the experience that was just articulated. Based on my experience, we do see jurors who articulate that they will believe a police officer. They're inclined to believe anything a police officer says. We also have a number of jurors who will indicate that they will never believe what a police officer says, and then lots in the middle. And I think it's our job to try and understand all of those people who are in the middle, in that gray area, whether they can actually be fair and impartial when they hear the particular evidence and testimony in the case that they might serve as a juror for. But I think we equally remove jurors who indicate that they would believe a police officer over and treat that police officer's testimony differently than other witnesses, just as we would remove a juror who would articulate that they would be unwilling to give a police officer's testimony the same credibility and believability merely because of their job. So my experience is just a little bit different than that
Right.
was articulated by my co-panelist.
My experience is dramatically different. My experience is dramatically different.
How so, Judge?
In that we dismiss jurors who would tend to believe police officers much more often than those that indicate they won't.
Well, what I would say is, part of the reason I think this panel is so great is that we have people from all over the country, from different jurisdictions who are having different experiences. What I would say is that I think as of recently, like the last 3 to 5 years, I think judges across the country have been much more vigilant on just that issue, Judge, about, hey, if you're saying you're going to trust a police officer, to an extreme level, we've got a problem there. I will say that during the time that I was practicing, expressions that you trusted police officers and believed in them were simply, let's move on to the next juror, because that was what normal Americans thought. And it was only the jurors that looked like me or the jurors that were from a problem neighborhood that had this problem with the cop. So if you have a problem with a cop, then you have a problem with the system. And if you have a problem with the system, then maybe you can't sit as a juror. What I'm hearing from both Judge Gates and from Judge Lowy is that dynamic is not static. And I think that's perhaps one of the most important things that I hope you get from this panel. This issue is in play. You've got someone from your highest court here talking about trying to wrestle with this. You've got Lila from the state of Washington where they wrote a completely different rule. Arizona with Judge Gates followed Justice Marshall, who said, you can tinker around with this all you want. The only way you're going to solve this problem is just get rid of peremptories altogether. This whole issue is wide open. And if you have thoughts about how this could be done in a better way, you can impact the jurisdiction where you're practicing. You're looking at the folks on this panel, it's like, well, that guy's a judge and this great public defender and another great defender and a judge in Arizona and this guy, Jeff Robinson, and we were all sitting where you're sitting. There is nothing extraordinary about any of us, except for the fact that we got interested in this topic and decided what would happen if we took our interests and used our intellect to try and think about it in a different way. What would happen? And you can see that this issue is radically changing all across America. So if you have views on this, I really want to encourage you, express these views, both when you're here in law school trying to figure it out, and when you get into your jobs. If you're a litigator, people are going to be interested in what you think. If you become a judge, you may be able to set a rule about how it's going to work in your courtroom. So thinking that these things are they're such old established things and they're never going to change is the thing that I want to rid you of, because all of this is open for play. It is open for business. And a lot of stuff in the entire criminal legal system is just that way. So I want you not to be limited by what you think has gone on. As I said before, peremptory challenges have a history that goes back to the 1200s. And yet, folks in Arizona said, yeah, that may be true, but we think we can do better without them. And folks in Washington said, yeah, that may be true, but they ain't going to be unlimited anymore. There's going to be a limit on it. Same thing in Massachusetts. So your responsibility as lawyers is to use your intellect to take rules, procedures, and regulations that are no longer serving the purpose that they were set for and to do something different with them. We've got 15 minutes, so if y'all don't mind, I would like to play this video very quickly because I want you to see, and it is so important. I agree with the fact that if I walk into a courtroom as a juror and I get excused and it's not because of my race, I'm not going to take that personally. It's like, hey, you thought I wouldn't be a good juror. I got other things to do with my life. That's fine. I'm not going to take that personally. But if you're excusing me because of the melanin in my skin, I got to go home and live with that. I've got to go home and somehow reconcile, pardon my French, God damn it, I worked my ass off to go to college, to go to law school, to become a lawyer, to be respected in the community, and because of the color of my skin, they say I'm not fit to serve on that jury. This implicates more than the litigants, and they even said that in Swain versus Alabama. It's the litigants, it's the juror, and it's the community as well. Just a second. Let me see if I can get this. I will get this started. I just have to. Press play. Can you see where the little arrow is?
Yeah. If you press that, it should work. I'm sure you all know that you have technical difficulties.
You do. I guess it would shoot. Yeah, you get it. There you go.
There we go. That was a question of the volumes up.
Yeah. Just give me 1 second. No, it's not what it should sound. I'm really sorry, the computer is not letting us share the sound. No, I don't think we're gonna get it. Yes, absolutely. Why don't we do that while I'm still trying to do this? If there are any questions that folks have for our panel members. Yes.
Thank you for the wonderful panel. I had a question about the sort of background assumption that is on the conversation, because I found myself thinking, peremptory challenges are by definition sort of arbitrary, which is rare that we accept that in the legal system. So I was wondering what's the justification for it, and then I heard a very compelling justification grounded in human dignity and participation in the process from the perspective of the defendant, and I heard a compelling justification based on the rights of citizenship serving on the jury. It strikes me that those things are not completely equivalent. And then I started wondering, do we need to have a symmetrical answer to this question, since the criminal justice system itself is designed to be asymmetrical anyway? What about a solution? And I know this is politically not feasible, but just as a thought experiment, isn't it the case that maybe defendants should get more peremptory challenges than prosecutors should get?
Well, in some states, that's absolutely true. In New Jersey, for example, that rule is under discussion, but I think prosecutors get 9 peremptory challenges and defendants get 20. So,
Seems to me that makes some sense in light of the other norms of the criminal justice.
and there were some colonies before the Constitution where the only side that got peremptories were the criminal defendant. So there is some notion in the whole concept that this is perhaps more important for the person who's standing trial. And so more peremptories are given to the defense in some states. Yes.
The majority of trials in Massachusetts happen in the district court, the 2 level courts, district and superior. Most serious felonies go to superior court. Most criminal trials happen in the district court. A large number of those happen for people without money, people who are determined to be indigent for whom counsel is appointed. For those trials, you get 2 peremptory challenges, just 2. And those 2 you have to be very careful. In many ways, the information you have is very limited because the system of voir dire that we have are not exceptionally robust. Part of that falls on the shoulders of the litigants who haven't pushed forward enough. We haven't pushed enough to be able to ask the questions that we need to be able to make smarter decisions that aren't just based on potentially repugnant snap judgments. And in many ways, a culture has formed in which there's not robust voir dire. Most of it is done by judges in the district court in particular. It goes by quickly. The example I gave was not one where I felt like I had done a great job during jury selection, but it is in some ways accurate. And so having a system in which there is more participation by attorneys, there's a larger opportunity for you would be very helpful. But what are we up against? Since COVID, right? We had no trials for about a year. There's a large backlog of trials, and it's not uncommon that that puts pressure, I believe, on the litigants and the judges in terms of jury selection. So,
Absolutely.
Yeah, I would say as in the federal system, prosecutors get fewer challenges than the judge. But I have a question for you as I'm interested in the party and adjunct here. It's interesting to me, so how in sort of practice does General Rule 37 work, and have you had prosecutors who are coming back to say, well, when I articulate my reason, right, so I may, as a prosecutor, say, I don't ever want scientists, or, you know, the old adage, I don't want engineers. And the one engineer happens to be a person of color. So have had any backlash in terms of that objective reason and, getting into, maybe the deliberative process and the final strategy that people don't want to. That's up to. Somewhat surprisingly, we haven't had a lot of backlash since GR 37. There was a ton of opposition to it before it was adopted. And in fact, our Supreme Court received probably a record number of comments, both pro and con about the rule when it was proposed. There's a public comment period anytime a court rule is pending. And there were very strong feelings both for and against. Prosecutors and others proposed an alternative rule that was framed as more protective, but we felt was really no more protective than Batson. And so the court had these two competing rules before it, and to their credit, they adopted the more protective proposal. But, despite the intense opposition from some sectors before the adoption of the rule, I think since the rule was adopted, people have gotten used to it and for the most part have endorsed it. And frankly, of course, the rule applies to everyone. It applies to criminal defense lawyers also, and prosecutors have lodged successful GR 37 objections against defense attorneys as well, and that's as it should be, because as Jeff explained, this right belongs to the juror and not just to any party.
Thank you very much. In the Ahmaud Arbery prosecution, defense lawyers were concerned about having Black people on that jury. So this has nothing to do with what side of the bench you sit on. The people, we're human beings that were born and raised in the United States. And so we have the ability to do this no matter what side of the bench we sit on. And one thing I just want to add quickly is this rule and the rule in Massachusetts that the judge is talking about, and even what's happening in Arizona, this makes lawyers be better at their jobs. In my view, the reason that jury selection has always been so limited is that we do a shitty job at it. And we're asking about license plates and bumper stickers, and you have two kids like I do. Isn't that cute? That has nothing to do with whether this person can be a good juror. And I would even say, I'm not upset about it. For the lawyers that say, I never liked engineers, my response is, then you're an idiot. Because every engineer is not the same. The fact that I have an engineering degree, I may also have a degree in applied who knows what. My views may be radically conservative or radically progressive. The fact that I'm an engineer, what that does, this is what lawyers have done throughout the history in the legal system. We take something like that. Engineers are analytical and they're cold and they won't deal well with a case that has emotion. So I don't want engineers. That is a way, a technique that we have come up with to make us feel better about ourselves and the decisions that we're making. Because what we're really saying is, I don't know what the hell I'm doing. Engineers, I heard somebody else say they're bad, so I don't want engineers. And so to the extent that these rules, what Arizona is doing with the questionnaires, what Massachusetts is doing, what GR 37 is doing in Washington, what it's doing is making lawyers spend more time thinking about what kind of opinions and beliefs that people have are going to be inconsistent with my theory of the case. And what I found is that the practice, the lawyer's practice of jury selection has elevated because we've been told you're no longer going to be able to get away with this kind of, presumptive thinking. You're going to have to actually articulate a reason why you don't want this person on the jury. And if it makes you think deeper and longer about who's going to sit on your jury, I would think your clients would be happy about that. Steve's client's going to be happier about it. I can tell you that for sure.
Jeff, I'm sorry to break in right now, but we're about to close, and I just want to explain to you guys, because it's super easy, how to get this video on your own. Go to tvw.org. That stands for tvwashington.org, which they film all state Supreme Court arguments and symposia and so forth. And then just search for 524-17. that date. And you'll find a symposium on jury diversity, and this speaker is toward the end. Okay, tvw.org, May 24th, 2017.
The other thing you can
And
do,
if you don't remember that, please have me
Yeah.
and I will make sure you have the
Can we post the link from that? Yeah.
sure, the other thing is that if you don't have a class tomorrow from 1:30 to 3:20, come because we're gonna be showing this video in that class.
And that class is Jeff Robinson's seminar that he's teaching in Stewart 402.
So let me just say, because we are running out of time, Judge Gates, I want to thank you. I wish you could have been here from Arizona, but it's cold and rainy here, or at least it's muggy and rainy here today, so you're probably better off staying in Arizona. And to our three panelists, could we just all get all of them? Thank you all so much for participating in this. And I hope it gives you some thoughts about what jury selection might be about. Thank you very much.
Thank you, everyone.
Thank you,
so much.
Judge.
And thank you, Judge Gates.